speakers today will be Loredana van den Waart, Irina Bora, and Irina Banu. Before we start, let's go quickly through the technical rules. Please keep your mic on mute all the time in order to avoid ear-splitting feedback. And if you have any questions, please address them in the chat, and we will read them at the end of the session. Now we will start with our first speaker, Loredana, who will share with us things to consider when setting up or expanding your business in the Netherlands. Loredana?
Hello, everybody. I don't know if you can see me.
Yes, we can hear you.
And you can see me also, because I'm not so sure it's...
We cannot see yet the share screening, the presentation.
Okay. I don't know. I think Irina is trying to do the screen sharing, and then I don't know if it's working.
I am on screen sharing. Sorry, I don't know why you don't see it.
We are in online problems are happening, so there is no worries. But I think we can. We cannot hear you. You are on mute.
Yes. Until then, I will try to present a little bit ourselves. We are a team of 7 at least lawyers. 3 of us, Irina, Ioana, and myself. We decided to start an association and a very tight collaboration in order to offer to all foreign investor and Romanian investor legal advice on business law. We 3 of us, which we are partners at BBW Law, are very experience in business law and working for more than 20 years with foreign investor in Romania. Our presentation will be from the Romanian legal perspective. We are Romanian lawyers registered with the Bar Association with a lot of tight relation with Netherlands, France, Belgium. But we try to give you some and present you some legal hints to which Romanian business people need to take care in the moment they decide to go and expand their business in abroad, especially in the Netherlands. I personally work with Netherlands also due of my family relation for more than 20 years with a foreign investment in Netherlands. But in the same time, I assisted also Romanian companies who decided to extend their business in Netherlands. And from this regard, taking into consideration also my specialty in international and European law, I study and can give you some information about the Dutch law, a few information about the Dutch law and about the differences and similarities between the Dutch law and the Romanian law. Of course, only a few legal hints. Not a detailed explanation of the Dutch law. We decided today to give you some information about some corporate matters, contractual, posting, and GDPR issue, which applies almost to all business in Europe, so it's not only strictly limited to Netherlands, of course, with a focus on investing and doing business in Netherlands. I will start my presentation. Irina, if you can help me with the next slide. And if you can put on all the screen. Possible. So as I mentioned, I will try to present you a few things about the corporate legal things in the Netherlands. When you, for a Romanian business company, it's important when they decide to expand their business to see how they will extend their business by incorporating a legal entity, only by contracts with Dutch partners. It's also possible to participate the public tender in the Netherlands, that tender that are open to all the European companies, so also included to the Romanian companies. It's also very important to do some research before to know where to address your question, and of course to know how to prepare this expansion of your business from Romania. So you have to take into consideration also the fact that the Netherlands is a different culture, not so different as the first sight we consider, because it's of course it's more German than Latin. But as I will present to you, actually the Dutch law system has his roots in French law as the Romanian system. So even at the beginning, maybe you consider that the system is totally different. So actually, there are a lot of similarities from these. Yes, I know.
Sorry, it was someone. We fixed it. Okay.
Also from the history and how the system was created, but also taking into consideration the European regulation, which applies almost the same in Netherlands and in Romania. Okay, doing business via legal entity, I will try to present you which are the most important legal entities that you can create in Netherlands. So there are two types of companies that are most used by foreign investors and by the Dutch people. This is BV, or Besloten Vennootschap. It's a private limited liability company, and it's similar with our societate limitată cu răspundere limitată. And the second one is the NV, Namloze Vennootschap, which is very similar with our societate pe acțiuni, and it's a public limited liability company. As in Romania, the most used and form of company is the BV, which is very flexible. It is also in Romania. There are, as I mentioned, a lot of similarities between the two form of companies, Romanian SRL and the BV. There is no minimum capital requirements. Now, could be also with one shareholder. It has to be registered to the Dutch Chamber of Commerce, KVK. And the only thing that is very important to notice is the fact that actually the article of incorporation had to be notarized. So it should be done with a public notary. The good thing is that you can do it through a power of attorney, so it's no need to go in person in Netherlands only for the incorporation of the company. In general, there is no establishment permit required. to start a business, except for a certain regulated sector, and I mentioned here food and financial sector. Regarding the NV, this is a company more for big companies with a share capital of more than 45,000 euro. I want to give you so many details on the NV because I think the most important for the moment is busy, and if there are some questions about NV, of course I will try to answer. In any case, for any details, we are working and collaborating with Dutch lawyers, so we can give you a common advice on a Romanian and the Dutch law by Romanian lawyers. We are Romanian lawyers, and by the Dutch lawyers, the lawyers with whom we are collaborating. Another possibility is also through a branch. Irina, if you can help me with the second slide, please. And I forgot to tell you, if you can give it back, about the Romanian formalities, which are very important. When you decide to establish a company in the Netherlands, also the Romanian mother company has to do some formalities, and this is a decision of the board of director, a decision of director, or a decision of the shareholder general meeting approving such investment. So it's important also to look attentive to your article of incorporation here in Romania, and to see which is the statutory body that should decide on these investments. Also, depending of your article of incorporation and your corporate powers, you need to decide also the related budget, the business plan apply to the future Netherlands subsidiary. Thank you, Irina. Now we can jump to the branch. Another possibility is to expand your business in Netherlands. It's also to create a branch. Sucursală, which from the legal point of view is very similar with our sucursală. It's also a form with no legal personality. So the branch cannot be considered a legal entity which is separated from the relevant foreign legal entity from the Romanian legal entity. That's why the branch is governed by the rules and legislation applicable to the mother company. Of course, for all the operation, for all the contracts, it will be a different law who applies depending of what the parties agree of, which is the rules of applying to that operation. This branch has to be registered also in the KVK, in the Dutch Chamber of Commerce. From the Romanian formalities, you need to know that the branch created in out abroad, also in Netherlands, has to be registered also with the trade register of the mother company. So if you have a company, for example, in Bucharest, when you register your branch in Netherlands, then you have to register also with the trade register from Bucharest. The branch, it's like it's only on information that should be appear in the Romanian trade register. I will only mention the fact that in the Netherlands, as in Romania, based on the European Regulation Council 2156, it's also possibility to create a European company. Of course, as this company is regulated by an European regulation, are the same provision that applies to a European company incorporated in the Netherlands and a European company incorporated in Romania. As maybe some of you know, European companies are mostly used for big companies which has more branches in several European countries. I think that was, in short, some legal hints of the legal entity that you could create for expanding your business in Netherlands. In the next slide, I will refer to some similarities and some contractual clauses that you should take care in the moment that you are doing business in the Netherlands and if you want to expand your business in the Netherlands through contracts. I only want to tell you that maybe most of you know, the Netherlands is one of the countries which has one of the most important trade in the world and also in Europe. Their legal system, as I mentioned also at the beginning, is very similar with all the continental European system because it's based on the civil code. Their first civil code was also the Napoleon Code, as the Romanian code. In 92, there was an important reform in the Netherlands as regards the civil code, and the new civil code, which applies now, it's more related with the German code than the French, but in any case, the principle remain the same as in Romania. So you have freedom to contract, but there are still also some provision that you have to take into consideration. Of course, Netherlands being in European Union, they apply all the regulation and all the directive issued by European bodies as Romania. I mentioned here two regulations which are very important between for the contracts between parties which have the headquarters in European Union. This is the regulation number 593. It's named regulation Rome 1. There is also a Rome 2, but this regulation is referring to the obligation which are not contractual. And also the regulation 1215, which refers to the enforcement of judgment in civil and commercial matter and regulate also the jurisdiction, the competent court. The most important clauses, except of course the object, price, obligation of the parties, which are normal and are similar like in Romania. I want to focus in my presentation on two of the clauses which are at the end normally of the contract and sometimes are forgetting by the parties, especially when the contracts are not drafted by lawyers because they are not considered so important. As we know, all the contracts are made in general for a situation when the parties are not reaching a settlement or have issues. And then these two clauses are very, very important when we are talking about contracts between companies which are from different European countries. Applicable law clause provide which will be the law applicable to that contract and how the rights and obligation of the party could be regulated if in the contract there is no provision or if that law provides some mandatory obligation. In general, in Netherlands as in Romania, we have a freedom of choice. So the parties could choose which is the applicable law. If the party don't choose, then it will be Rome 1 who applies. And in general, there are, of course, provision for several types of contracts, but the general provision is saying that the applicable law is the law applicable in the country where the party required to effect the characteristic performance of the contract has his habitual residence. For example, in a sale contract, it's the seller headquarters or domicile who apply, or otherwise is the law applicable to the country with which is the most closely connected. So this you have to take into consideration when you assign your contract. Another important clause is this jurisdiction, who will be the court who will decide on your contract if there is any litigation or dispute between parties. And again, here you have a freedom of choice between the parties. What we recommend is to have the courts of the same country of the applicable law, because otherwise it is possible to have a court from Romania and applicable law from Netherlands, but it will be very difficult because a Romanian judge should apply the Dutch law, or vice versa, a Dutch judge should apply the Romanian law if there is differences. So that's why it's important to provide expressly in your contracts which are the competent court, which is the applicable law. Again, to the jurisdiction, there is the regulation 1215 who applies, and in general, when the party are not choosing the competent court, then the competent court is the court of the defendant. Or it's the place of performance of the obligation in a question, that obligation which is in a dispute. This is an alternative jurisdiction. So the plaintiff could decide when he introduces his legal action if he goes in front of the court where the defendant has a domicile, or where the place of performance of the obligation in question happened. Yes, I will stop here my presentation on the corporate matters and on contracts, and I will give the floor to my colleague Irina Bora, who will present you some legal things on posting. Thank you very much. And if you have questions, please address them at the end.
Hello, it's nice to meet you, everybody. Thank you, Loredana. I will speak about the workforce that you will be employing when expanding your business to Netherlands. So Loredana told you about how you can expand via creating a legal entity or via contracts. In any of these two cases, you will have employees. Either you have your own employees here in Romania that you want to post to Netherlands, or you want to employ local Netherlands Dutch employees. You will need to consider in advance which are the formalities for the employment agreement. I will focus more on what happens when you want to send your employees from Romania to Netherlands. The option is to have local Dutch employment contracts, which are regulated fully on the under the Netherlands employment rules. But if you are posting your employees from Romania, you have to consider formalities in Romania and formalities in Netherlands. Joanna, can you please go with the next slide? Okay, thank you. So it's you will have in dark blue the obligation that you are going to have here in Romania, and then in light blue is the obligation that you will have in Netherlands. What is very important is to have all these questions addressed before engaging in any posting or in any assignment to Netherlands or to any other country, because we will have first to adapt your local employment agreement. Then you will have to deal with these social security matters, which are very important in case of working in 2 or more countries in a short period of time. And on the last step, you will have to deal with all the formalities of the hosting country, in this case, Netherlands, to see what are the registration requirements, the notification requirements, and all of these have to be performed in advance. So the main situation in which you can have this posting or these transnational services of personnel are if you are sending your own personnel to the Netherlands to carry out a posting or an assignment, or if you are temporarily seconding employees to a group company, it can be the mother company, or it can be a branch or a subsidiary. Or if as a Romanian interim agency, you make temporary workers available in the Netherlands. More or less, we will have the same rules applying, with the first step adapting the employment agreement from Romania. There are some specific particular clauses that need to be inserted in the employment agreement before a posting to another country. So we will see them on the next slide. Okay. So of course you have, for each posting, the employment agreement has to be adapted to insert the duration of the assignment, the country to which the employee is assigned, in which currency, and how the salary will be paid, and which will be the salary and other pecuniary rights during the assignment, including the transportation and the housing, which are always on the employer's side. In the same time, a part of the mandatory clause to be inserted in the employment agreement, you will have to inform the employees before going to Netherlands, which are the main labor-related regulations in Netherlands, which are the climate conditions in Netherlands, and the condition for repatriation if the case. We, as Loredana said, we are working closely with the Dutch lawyers to give you an integrated advice, combining what you will have to do in Romania before leaving from the Romanian side, and then to have in the same advice what are the formalities and what are the scope of this obligation, to prepare the information notice to the employees before leaving. You have the next slide, please. Okay. What is also very important to know is that when you are sending your employees to the Netherlands, be it for 1 month, 1 day, or 1 year, for the duration of the assignment, you will need to comply with the minimum condition of employment in Netherlands. There are 2 sets of rights which have to be addressed. On the first, or for assignments under 12 months, or in the first 12 months of an assignment, you will have to comply with the Dutch minimum wage and holiday allowance. The Dutch minimum wage is adjusted twice a year, at the beginning of the year and then in July. There are different thresholds depending on the age of the employees. So for full-time employees starting with 21 years, it's currently it's around 1,700 euro. So this will have to be granted to the employees when they are going to Netherlands, even if they are remaining on the employment agreement concluded in Romania and they are remaining on the payroll of the Romanian company. But as long as they are working in the Netherlands, these core rights will have to apply. So we are speaking about minimum wage, we are speaking about resting hours, about the number of holidays, the holidays in Netherlands, and also for the condition of health and safety of at work as they are provided under the Dutch regulations. After 12 months, this hardcore part of rights which applying irrespective of the nationality of the employee, is that you will have to comply and to grant the employees all the rights which are provided in the collective labor agreements applicable in Netherlands, except for the dismissal protection and additional company pensions. And this is very important also to be addressed from the start, because you will have an employee under a Romanian employment agreement, which may benefit in Romania from a collective labor agreement. And you will also have the collective labor agreement in Netherlands, which could apply. In Netherlands, as in Romania, but in Romania it's less expanded, you can have a collective labor agreement declared binding for your sector of activity. So if this is declared binding, even if you do not have an entity in Netherlands, as long as you have people working there, you will have to know it and then to observe it. Now that's why it's very important to have all the condition of employment and to know which law and which contract applies at which time. Going further, I will speak a little about the social security system, because this is a very important part of the employment. When the rule under all EU countries is that an employee is protected under the social security system of the country where he or she is working. Ioana, can you please pass on the next slide? Okay, thank you. But this can be very complicated to achieve if we are speaking about a lot of workers posted or posted for a limited period of time, because this would mean, for instance, that if you are posting an employee for 2 months, he will be out of the social security system, out of the pension system in Romania, out of the health system in Romania, and insured in Netherlands. To avoid this change of legislation, the EU rules allows for a period limited in time to ensure continuity of the worker under the Romanian social security system. This can be achieved by, not yet. Can we go back? Okay. This can be achieved by obtaining A1 certificate. Once you have the A1 certificate, this means that you will continue to pay the social contributions here in Romania, that the employee will continue to be insured in Romania for the time of its assignment in the Netherlands. The social security authorities in the Netherlands cannot ask you to register in the Netherlands or to pay the related social contributions there. A switch of the social security system will be required if the assignment or the posting exceeds 24 months. There are some exceptions, but this will have to be addressed on case-by-case basis. And this is also very important to know from the beginning. If you plan to have a posting which will be longer in time, to address from the beginning maybe a registration with the social security system in the Netherlands. These are in general the formalities that you will have to think about here in Romania. And the second set of formalities are those in the country of hosting, which will be Netherlands. And now we will pass on the next slide. And we have new rules as of 2020 in the Netherlands, which are requiring non-line notification prior to any sending of employees in the Netherlands. So all employers abroad, so this will be a Romanian employer wanting to send employees or personnel to the Netherlands, will have to notify the Dutch authorities about the anticipated posting. The notification is made online. The portal is quite user-friendly. It's also available in English and German. But before going there and start filling in the notification, we will have to have all the documentation, the supporting documentation, because there are a lot of information which are required to be inserted. One very important point is that you will have to have a contact person or a point of contact present in the Netherlands, which have to be notified to the Dutch authorities, and the Dutch authorities should have the possibility to contact that person at any time and to ask for additional information or for additional supporting documentation for the posting. There are some cases in which this duty to notify does not apply, or more for incidental work, if there is, for instance, a first installation of product but which does not exceed a certain number of days, or for participating to conferences or to courses. So it's important to address these questions in advance with the advisor, to know if you really have to notify or you can rely on some exceptions. Because if you are required to notify and you don't do it, there are some important fines. There are also fines on the service recipient. Okay, when you are sending employees to Netherlands, if you are sending them to a group company, or if you are sending them to a client with whom you, or to whom you are providing services, he will automatically receive the notification. He will have to review it, and he will have to confirm or to inform it. So the notification will be considered completed only when when both parties, the employer abroad and the service recipient, are confirming it. These are the main rules, the main formalities. There are a lot of things to prepare about before posting your employees to the Netherlands. We are here to help you. We are here to help you along with our correspondents in Netherlands, and we will be happy to do it. Linked to the employment and to the labor employment, Ioana will take the lead now, and she will speak about the data protection for employees, but not only as a data protection in business.
Thanks a lot, Irina. Hello, everybody. I hope everyone is doing well on this gloomy day. I would like to thank the Chamber for this invitation, and also to my partners for their presentations before me. My goal today is to give you some very practical tips regarding this GDPR regulation that I assume all of you know about. After my short presentation and tips, my suggestion is that you go ahead and come alive with me or via messages to so that I can address directly all the questions that you may have. So basically, what is this GDPR that everyone is talking about? Today, we are discussing about the way it applies in the Netherlands, but of course, GDPR applies in all the member states. So everywhere, any company that is based in the EU is subject to these really complicated rules that may trigger incredible fines. So remember that the first thing actually that I want to say is that GDPR can trigger a fine up to 20 million euros or 4% of the worldwide turnover of a company. This can ruin forever a company. So this is actually why the hype is so big now regarding GDPR, because the fines have become so high. And I want to say that me, together with my partner Irina, let's brag a little bit, we've been handling data protection matters long before the GDPR revolution. So GDPR, the main thing that brought is these incredible fines, and people are starting to really look into what data protection involves for businesses. But let's think about the setup today. At this very moment, we are processing personal data, names, images, voice. So it's very important for everyone to actually have some knowledge regarding personal data for the protection of ourselves as individuals, and of course for the protection of our businesses. Because it happens, I had clients come up to me after a data breach that, for example, can not even be the direct fault of the client. And now they're in this situation when in 72 hours, they have to actually inform the data protection authority about this data breach, or else they are subject to these fines. And this is a moment when it's almost too late to act. So maybe like with every legal foundation for everything, what has been discussed today, so corporate contracts, posting, employees, it is so important to start with the legal foundation, to not seek counsel when everything goes wrong, because at that point it can be too late. And I'm talking about major companies that, for example, did not have this in place, so a procedure as regards a data breach. I want to share with you also that in 2020, because of the COVID situation, hackers have been really growing, and a lot of companies were attacked. So I'm not talking about a data breach where it's the company's fault, but a data breach where it's not even your fault. Maybe it's a service provider's fault. So it's very important to begin with a legal foundation. I want also to point this out because maybe some of you have businesses outside the EU. So I said GDPR applies to EU companies, applies of course to companies in the Netherlands, but it also applies to another situation. If your company, your business is based outside EU, but you are targeting with goods or services people in the EU, then GDPR also applies to you. Of course, Facebook is a classical example for this because it's based in the States, but it processes, and of course not in a very legal way at times, our personal data. So beware of this, because this is another issue that I encountered a lot. Companies are not that aware that they are subject to GDPR, even if they're in the States, because they are targeting people in the EU. So this is very important as regards the way GDPR applies. And now I want to tell you a story today about a business. So let's say that tomorrow you want to start a business, an online business. So you want to start a website. The moment you want to select your website, you have to consider, where is my server located? Because for instance, if it's not in the EU, you will automatically send data to a non-EU country. And this can trigger a lot of fines and problems. So from the very beginning, it's important when you set up this website to see where it's located. It should be located in the EU. Then for your website, you also have to have a privacy notice. I think we are all kind of sick of this. Every time we enter a website, there are millions of privacy notices, cookies notices. I will try today also to explain a little bit what's up with these cookies that we hate, unlike other types of cookies. So we are bombarded with this. It's very important when you set up your website to have this privacy policy. Basically, there you have to inform the individuals, the users of your website, what you are doing with their data, how you collect them. This has to be very transparent. So it has to be very easily understood by the user. And for example, if you will check out Facebook's privacy policy, you will see that it's not that easily understandable, because high players usually on purpose use this kind of language to not make it so clear what they are doing with our personal data. And I assume that you know about the huge scandal with Cambridge Analytica, so the way Facebook sold our data, our personal data, in order to influence a political choice. We are talking about elections in the United States, so against Trump and Hillary. Basically, they were using data of people who were not yet decided who they want to vote to push advertising for Trump in this case, and other things as well, where other political things were influenced by the way Facebook sold or just left our data there for this Cambridge Analytica that had nothing to do with Cambridge. It was just a data company. So usually when the privacy policy is not clear, it can hide something in the back of that privacy policy. So it's very important for you, after you, for instance, have this website, to have this privacy policy where you clearly explain to the person what you are doing with their data and why you are using their data, because you have to have always a valid reason for the way you are using someone's data. It can be that you are entering a contract, that you are obligated because there's a legal obligation for you to process that data. But you have to identify specifically for each processing activity and each data what you are doing with that data, what the reason according to GDPR is. This may sound, so a lot of times it can sound so complicated, but it's not. It's very smart. And once your business and the people who are in charge with this understand the mechanism, it is easy to react anytime you have to process personal data. Okay, so we are talking now about the website. Of course, then we are talking if you are a business of B2C, so directly targeting clients, individuals. You will have a huge database with your clientele, of course. And this can trigger a lot of issues because you have a lot of special data. You can have special data in your computer. You have to safeguard this data. So when you when you look at a business from the perspective of targeting clientele, this is, to sum up, your website has to have bulletproof privacy policies, cookie policies, because as you know, when you visit a website, we are bombarded with these stupid messages. We are using your cookies. This is it. You just say yes because you want to get to the site. But the truth is that this can also be a personal data. It is imperative that you know for real what your site is collecting. And if you can, only collect the necessary cookies for your site to work. Because many people are collecting cookies, but they're not even using those cookies for their business. And let me explain a little bit what cookies are. So basically, it's just a file, a file with text and numbers. This just glues itself to your device, be it your phone, your laptop, and it tracks you. It really tracks you to monitor your behavior, because the person who is selling something on his website wants to know what your preferences are, why you put the product in the basket, but then refused to buy it and then went on a different site. So this can be used for analytics. This can be used for companies in their business. It can create value in a business. But many businesses use these cookies, are unaware that they are using them. They do not use them for business purposes, and then they get fined when it is actually revealed that they've been using unnecessary cookies. So why I'm saying that it's important from when you start your business. After you set up a website, it can be very hard to actually change these things. It can be very burdensome financially to stop collecting some cookies. It's a technical procedure behind. So it's very important, like in any business and in any domain, to start directly with a solid, accurate legal foundation from the very beginning, because it's very hard to change them afterwards. Okay, we talked a little bit about the website. I'm very eager to learn exactly what businesses you are into, to see exactly how we can help you with some advice. But now I want to also tackle, since also my partner has been telling you about posting of employees. So another very important issue, of course, when you have a business, be it in the Netherlands or whatever, you will have employees. And of course, employees are individuals, and of course, you process their personal data when you enter into a contract, even when you have an interview. So let's say today you have an interview with someone you want to recruit. You will not recruit them. You are just having this interview. You are processing their personal data. And it's important to have a privacy notice again, whereby you explain to that person what you will do with that data, how long will you keep it, because you are allowed to keep that data for some time. So there's a solution for every problem in GDPR. This is what I love personally about GDPR. But it's imperative that we understand how this applies to every portion of the business. So you have to have this privacy. So basically the same thing that you have to have for your website, you have to have also for the people that you wish to recruit and for your employees. For your employees, you have to explain why you are processing their personal data and what the ground, so the reason for processing that personal data is. This is highly important because there are many problems regarding processing that is over what GDPR allows. For instance, monitoring the employee at the office with cameras. So this is also a very important principle in data protection. Just collect what you need. Do not collect more. Do not collect someone's phone number. If you do not need it, if it's not really necessary for you, don't do it. Just collect what you need to enter into a contract, to fulfill a legal obligation, and things like this. Do not collect more. It is very important, and this is a principle according to GDPR. You always have to remember that usually a fine is triggered by a person that is unsatisfied with the way you've been handling their personal data and the way your bureaucracy is set up. Because the only slide I actually want to share at some point is to show you in the Netherlands, since we are talking about the Netherlands today, what fines have been applied in the last 2 years. And let me give you one example. TikTok was fined with almost 1 million euros for this simple thing. You know, TikTok is that app, you know, with dances addressed mainly to kids, to children, and it's very popular in the Netherlands. And they did not have this privacy policy I've been talking about, that you have to have for customers, for employees, and so on. They didn't have it in Dutch. So the kids were not maybe able to actually understand it because it wasn't in Dutch, it was only in English. And this triggered a fine of almost 1 million euros. So bureaucracy is, unfortunately, is very important in GDPR. And what I want to explain to you, because the way I'm speaking to you, I'm speaking to all our clients who process data on a large scale. It's important to talk like this about GDPR, to start making people understand exactly what it's about in normal language. And that's exactly what GDPR says. When you want to inform your people how you are processing data, be specific, be clear. Do not use that language, you know, that is not clear and it's even boring, or use clear language so that that person really understands. And if we begin to discuss about GDPR in clear terms, you will see that in the end it's very smart and it can be understood, and the same principles apply in all your relations. And now I'm going to give you another example, because so mainly I talk now about a business to client kind of corporation, but it's, let's say, a business to business. So when you have third parties involved and the client is like an end user, you know, in this type of situation, it is also very important. It's always important, but especially here, to know who is the data controller and who is the data processor. The data controller, maybe you heard of these terms, is the one that decides what to do with that personal data. But as a business, if you hold that data, you will have other service providers who will be processors on your behalf. You will just give that data to them and tell them what to do. Let's give an example for this. For instance, an HR company. So you have a third party, a company, who is processing, who is taking care of everything for your employees, payroll, stuff like that. So this company is processing on your behalf data. It's very important, another thing that is highly fineable, to have an agreement regarding the way data is processed between these parties. So this is another point. It's called a data protection agreement. It's like a schedule to all your services agreement. This is important. One, if you don't have it, the fine is huge, as I've been talking about before. And secondly, it's important with all your business partner to actually say in plain English who is the data controller and who is the data processor. This is something that is the most difficult part to understand in GDPR, because only I think we've been working for so long, for so many medical staff, brokers, and it can happen that only on one portion someone is a data controller, the other a data processor, and then again the roles are mixed. But this is important to identify because the data controller is the one who holds liability. So if I hold the data for my clients, I decide what to do with it, I email you, and so on and so forth. I am the data controller, and that means I hold the greatest liability according to GDPR. I'm liable for what I do with the data. So even what the others, my service providers, what my HR company is doing with the data I give them in order to fulfill the contract, I'm responsible for that as well. So the way the contract is drafted, it's very important. GDPR gives you some, let's say, mandatory things that you have to have in the contract. But a good lawyer will also draft the contract to protect the interests of the client, who can be either the data controller or the data processor. So we cannot run from GDPR. It may seem, like we want to bury it and forget about it sometimes, that it has destroyed our lives and made the lives of lawyers better, probably. But we cannot run from it. And being very diligent and assessing every possible situation is actually the way to keep it in check. Let me give you another example of a fine, again in the Netherlands. So it was an authority, an institution, who was fined because in a public space, the free wireless was actually tracking people. It was possible to somehow gather data to actually know when a person was working in a building, for instance, was hanging out at that place. And they didn't know about this. So again, they weren't aware. They weren't doing this with a, devious purpose. So it's highly important to assess also from a technical point of view what you are doing. What do you have in your computer? What kind of data are you holding? And now we get to another point, the rights of the data subjects, so basically the individuals. You have to inform any person whose data you are processing what their rights are. And one of these rights is the right to erase, to have your, the right to be forgotten. I think we've all heard about this. For instance, I can now send a notice, an official notice, to a company that has been targeting me to say, I want all my data erased. And this can happen to you as a business. This can happen to you. And some people get scared. They're like, okay, I will erase everything. Oh my God, what's going on? No, the right counsel will explain that this is not an absolute right. So sometimes you need to keep that data to protect yourself as a business owner. For instance, I told you about that example with an interview. So the person comes, you interview the person, but you are allowed to keep the personal data of that person for a number of years after they leave, even if they don't want to, because in case they sue you, for instance, they say, look, I actually deserve that job. I was being discriminated against, for instance, you have to have some data in order to protect yourself in court. So it's a game of knowledge, strategy, and good bureaucracy. Because as I told you, many fines are being given because of bureaucracy. So I'm talking major players like Twitter, or just a small error, maybe in the privacy policy. And sometimes we do not know what's behind a simple privacy policy. I mean, where is that data, It's not only about technical stuff to actually look to see what that person holds about us. It's a lot more a game about knowledge and bureaucracy and good identification of every player. So there are many people that confuse, that say, for instance, us lawyers, we are also data controllers. There are people who say that we are processors because we are doing what the client says, but we decide what to do with the data. So it's highly important to identify, and this is another point, to identify very well what you are in a certain operation. Do you control that data? Do you decide what to do with it? Then you are a controller. Are you a service provider that are, for instance, let's say that you are a software company and provide cloud services. Then you are a processor because you have this agreement with the data controller who's giving you the data, and you are doing everything as they say. You are not deciding what to do. So in almost all these services, one part maybe you are controller, but you are basically in principle a data processor. And if it takes smarts, to actually assess this. And it's important to do it well because you can endanger your status by not identifying properly what you are according to GDPR, considering a simple data processing operation. Another thing that I wanted to discuss with you, of course, GDPR is a diabolical regulation that we can talk about this from my perspective all year, nonstop. I'm trying to just give you some really fast tips, that may help you from a practical standpoint. You also have to be very careful to not send data to a non-EU country. So this is important because maybe sometimes it's not clear. For instance, I give you this example about the cloud. You're just, you want to have a service provider. You're just concluding a contract, but maybe you are not aware that you are sending data to a country that is outside EU, and that is a major thing. So you need to be careful. Maybe you've noticed now that Amazon and all kinds of service providers now also have servers in the EU, EEA, and outside because they know about this problem. So they want to conclude to use the servers in the EU for EU entities. So it's very important to also tackle this. I can give you another example for employees. For instance, if you have a stock option plan, a lot of our clients do, so to give incentives to their employees. And again, you are processing data there. You have to be very careful to see what data you are sending maybe to the shareholder who is in the US, for instance. And the legal grounds. This is the last point I want to discuss. And I hope that at the end you have questions or you want to go live, because my point of view is that the best way is to have an open conversation and to answer to all your specific questions. So the last point I want to discuss is that you really needn't be scared about GDPR. It is highly important to have like a training for your personnel. This is what we do normally. We go at our clients and have this training. One day we sit with everyone, employees, major shareholders, CEOs, and we explain. And this is something that as I said, it's important for us also as individuals, not only as companies, but all the people who work with you have to know about GDPR. They have to be responsible, liable for what goes on in your company. If they do not know what personal data is and what they have to do with it, how they have to keep it secure, how they don't have to ask for more data than allowed. If they don't know this, you will be liable as a company for what they do. So it's very important to tackle every player in your company, every business partner, every employee, even the servers where your website is. You have to be careful, for instance, some personal data. If you have, for instance, for your clients, the possibility to buy via your website, that financial data, the data for their credit card and things like this cannot be stored unless you have other authorizations. So it's not even about GDPR. So these things are complicated. They can trigger a lot of fines. And the best way to solve them is to have this training, because this is the way everyone understands. And you can have a clear view of the actions you need to take, from like red, super important, red phase, so those things that are major, yellow phase, green phase, and so on, because it's virtually impossible to do them all at once. And this is a presentation for people who, of course, for businesses who, of course, do not process sensitive data, like, fingerprints. Another fine that I saw was given by the Dutch DPA was this. The employer was gathering the fingerprints of their employees, because they were using that to use the elevator, but they were storing that information. And this is highly unacceptable, and they weren't aware. So it happens at major players that they are not aware of something that they are doing, and can cause these immense fines that really can kill the company as a whole. So this is my presentation. I think I already had a long time. Thanks everyone for your patience. I hope that at least a few things I managed to explain. There are a lot of tips that can be given, but if you leave with something after this discussion, it is that not only in GDPR, in everything, don't go to the lawyer when things are a mess. go at the lawyer with your structure, with your legal foundation, and start doing it right from the very beginning. And it's not about me saying that lawyers are the best and they need to be used. It's about seeing what financial burden it is for the clients if they do not do this, especially in GDPR. It's very important to start from the very beginning with the training and documents in place. It's something that we cannot actually run away from. You either love it or you hate it. For me, unfortunately, I still love it, so that's it. Thanks everyone, and if you have questions, please, I'm glad to answer, or if you want to go live.
Thank you, Ioana, very much for everything that you share with us. Very, very interesting. And GDPR, I think, will remain a very important subject for a long time. So if anybody has any question, please, you can address them live or in the chat box. Or if not, you can send them directly to info@nrcc.ro and they will send them to you. So I see that Mike said that he would be interested in having a more in-depth discussion with you, Ioana. So you are on mute. You are on mute.
Okay.
So maybe you will get in touch. Okay,
sure, Mike. It's a pleasure.
Thank you so much, Ioana. Great presentation. I'd love to discuss this with you because we are operating as I said, a global marketplace, and the location is in Canada, but we are incorporated in Romania as well.
Mm-hmm.
Actually, we're incorporated in the US, in the UK, in India, and currently in the process of incorporating in China as well. So I would like to kind of discuss a little bit more. I can send you my email. I can send you maybe an invitation to connect on LinkedIn.
Yes, of course. You can find me on LinkedIn, Facebook, everywhere, and you can send me now if it's fine.
I will. Great presentation. Thank you so much, Ioana.
Thanks very much. Thanks.
Anybody else? Apparently, at the moment, nobody wants to ask anything. I think the presentation was so clear that they got all their answers. Do not forget that today we will host another event starting with 3:30 regarding cultural differences on the work floor. Thank you everybody for participating today. Thank you very much for the important presentation to you, and looking forward to seeing you at 3:30. So
thank you very much, everybody.
Thank you very much. Have a nice day.
Have an amazing day.